Chapter 18, Performance and Discharge. There are a few parts to this chapter, but the first one is conditions. A qualification that is in a contract for a future event. An occurrence of the event will terminate the existing obligation under a contract. If a condition is not satisfied, then the obligations of the party can be discharged. There are three types of conditions: precedent, subsequent, and concurrent. Conditions can also be classified or implied. Condition precedent is a condition that has to be fulfilled before the party's performance can be required. Condition subsequent is when a condition operates to determine a party's absolute promise to performance, and these are rare. Conditions concurrent is when each party is conditioned on the other party's performance. Both parties must perform their duties simultaneously. Express is where provided in the parties' agreement they use the words if or provided. Implied is when it is understood to be a part of the contract depending on the purpose. Courts may give conditions from the contracts or from the parties. Discharge by performance is the second part of this chapter. Both parties do their duties by performing the acts they had promised. Tender of performance is an unconditional offer to perform. Complete performance is when the parties perform exactly as agreed. All conditions are satisfied. Substantial performance is when a party is in good faith and they perform substantially all of the terms that can enforce the contract. Measure of damage is the cost that brings the object of the contract into compliance with its terms. If it is not reasonable, then the measure of damages is the differences in value between the performance rendered and complete performance of the contract. When the contract is personal, then the performance must satisfy the party specified in the contract. Reasonable person standard is when most other contracts need to be performed only to the satisfaction of a person unless stated otherwise. Material versus minor breach is when a breach is minor, then the non-breaching party's duty may be suspended. Once the minor breach is cured, then the non-breaching party can resume performance. Anticipatory reputation is the refusal of one party that carries out his or her contractual obligations before either party has to perform. Time for performance is if there is no time stated in contract, then time is implied. Discharge by agreement is another part of the chapter. Discharge by mutual recession is when parties must make another agreement that satisfies legal requirements for a contract. Discharge by novation is the substitution of a new third party for one of the original parties. Discharge by operation of law is another part of this chapter. Material alteration is if the innocent party is discharged after material alteration of the contract terms. Statutes of limitations are a suit for breach of contract that must be filed within the time permitted. Bankruptcy prevents creditors from enforcing most debtors' contracts. When a performance is impossible, then types of situations may allow for discharge of contractual obligations. Commercial impracticability is when parties may be excused from performance if more difficult or expensive than parties had expected. Frustration of purpose is when a contract will be discharged if circumstances may make it impossible to attain purpose of both parties when they made the contract.